Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. If you're studying for the bar exam, this case summary is one you need to understand cold. Have you ever tried to haggle for a better price, only to find the seller walked away completely? In this video, we use the classic Hyde v. Wrench case to show you why a counteroffer is legally a rejection and how you can protect your interests during a high-stakes negotiation. Let's start with the real-world problem. The moment you try to change the terms of a deal, the original deal may improve forever. Imagine someone offers to sell you a property for $1,000. In the 1840 case, Wrench offered his farm for £1,000. At this stage, you have the power to create a binding contract just by saying yes. But the moment you hesitate or try to change the price, that power starts to slip away. Hyde responded to the £1,000 offer by offering £950 instead. Most people think this is just starting a conversation, but legally, it's a rejection of the original offer. You're essentially saying no to the first deal and proposing a brand new one that the seller has no obligation to accept. When Wrench refused the £950 offer, Hyde tried to go back and accept the original £1,000 price. This is where most people get burned. Once you've rejected an offer by countering it, you can't unilaterally revive it later unless the seller agrees to it all over again. To have a valid contract, your yes has to be a perfect reflection of the offer. If it's not, you're in a legal grey zone. The mirror image rule means that your acceptance may want to match the offer exactly. If the seller says as is and you say yes but clean the gutters, you haven't accepted the contract. You've actually made a counteroffer that the seller can walk away from without penalty. Be careful with phrases like "I accept," provided that, or "subject to." These are red flags in a negotiation. While they feel like progress, they're legally treated as rejections of the current offer, which could allow a different buyer to swoop in and take the deal. There's a safe way to ask questions without harming the deal. A mere inquiry, like asking if the seller would consider a lower price or different closing date, doesn't necessarily negatively impact the offer. The trick is to keep it as a question rather than a statement of new terms. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Negotiating is a high-stakes game. If you don't recognize these red flags, you might end up with no deal and a lot of wasted time. If you send a counteroffer and the seller goes silent, don't assume they're thinking it over. Legally, they may have just moved on to the next buyer. Since your counteroffer killed the original deal, they have no legal obligation to even respond to you anymore. While you're busy haggling over small percentages, a seller is free to accept a clean offer from someone else. Because your counteroffer terminated the original offer, you no longer have a first right to the property or service at the original price. In many jurisdictions, especially with real estate, verbal agreements aren't worth the paper they aren't written on. Hyde v. Wrench reminds us that even when people talk about prices, the written chain of offers and rejections is what the court will look at if things go wrong. So, how do you actually win a negotiation? You need a framework to decide when to haggle and when to just say yes. Before you counteroffer, ask yourself, is this $500 savings worth losing the entire property? If the market is hot, any counteroffer is a massive risk. If the property has been sitting for months, you have more leverage to may negatively impact the original offer with a counter. If you find a may want to have deal, the safest move is a clean acceptance. By matching the seller's terms exactly, you lock them into a binding contract immediately. This prevents them from entertaining higher offers that might come in later that day. Contract law varies by location and the type of asset. If you're dealing with complex terms, easements, or significant sums of money, don't try to be your own lawyer. A licensed professional can help you phrase inquiries as they don't accidentally may negatively impact your deal. The lesson from Hyde v. Wrench is simple. A counteroffer is a no to the old deal. Before you try to negotiate, make sure you're okay with the original offer disappearing forever. Use inquiries to gather info and use clean acceptances to win in competitive markets. If this guide helped you understand the risks of negotiation, like and subscribe for more practical breakdowns. For more resources on navigating contracts and professional standards, visit Bar Exam HQ. Always consult a qualified professional before signing major contracts. Subscribe for more case summaries that make bar exam prep easier. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.